Welcome back to one more session. Today in this video I am going to explain about uh, unsoundness of mind or insanity. Section 22 of the Bharatiya Nyaya Sanhita 2023 deals with act of a person of unsound mind. According to that, nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act or that he is doing what is the either wrong or contrary to law. Section 22 states that unsoundness of mind is a defense of a person to a criminal charge on the theory that one who is insane has no mind and hence cannot have the necessary mens rea to commit a crime. Being deprived of free will, a madman is placed in even a worse predicament than a child, because the latter can at least control his will and regulate his conduct, whereas the former cannot. In fact, a madman is punished by his own madness. Moreover, the act of an insane person being unintentional and involuntary, no court can correct him by way of punishment. But at the same time, the society has to be protected against the attack of maniac. Accordingly, a provision has been made under Section 369 of the Bharatiya Nagarika Suraksha Sanhita 2023 for the detention of such persons in lunatic asylums. Unsoundness of mind is a commonly termed insanity, and according to medical science is a disorder of the mind which impairs the mental faculties of man. In other words, insanity is another name for mental abnormality due to various factors and exists in various degrees. Insanity is popularly denoted by idiocy, madness, lunacy to describe mental derangement, mental disorder, and all other forms of mental abnormality known to medical science. Thus, an uncontrollable impulse driving a man to kill or wound would come within the scope of the medical definition of insanity. However, insanity in law differs markedly from the medical concept. Insanity in law means a disorder of the mind which impairs the cognitive faculty, that is, the reasoning capacity of a man to such an extent as to render him incapable of understanding the nature and consequences of his actions. To invoke the benefit of section 22, it must be proved that at the time of commission of the offense, the accused was insane, non-compos mentis, not of sound mind, and that the unsoundness of mind was of such a degree and nature as to fulfill one of the tests laid down in this section. These are: first, the accused was incapable of knowing the nature of the act, and secondly, that the accused was precluded by reasons of unsoundness of mind from understanding that what he was doing was either wrong or contrary to law. The first category covers two situations, namely automatism and mistake of fact due to unsoundness of mind as a defense. For instance, if a madman cuts off the head of a man sleeping on the road because it would be fun to watch him searching for his head when he awoke, that act shows that he did not know the nature and quality of his act. In fact, he has no idea what his fun could never happen. The moment the head was separated from the rest of the man's body, as the man would never recover consciousness. The second category covers those cases wherein a man, by reason of delusion, is unable to appreciate the distinction between right and wrong. For instance, in Shibo Koiri, in which the accused killed his uncle by severing his head and neck with a sword while shouting "Victory to Kali," and thereafter attempted to strike others including his father. It was held that the accused case fell within the later part of this section. It was found that the accused was suffering from a fit of insanity at the time. He attacked the deceased with the sword and was, by reason of unsoundness of mind, incapable of knowing that he was doing an act which was wrong or contrary to law, and hence he was acquitted of the charge of murder. There is a case law, that Surendra Misra vs. State of Jharkhand 2011. In this case, the Supreme Court held that an accused who seeks exoneration from criminal liability of an act under section 22 is to prove legal insanity and not medical insanity, merely because the accused is conceited odd on his brain is not all right, or that the mental or physical ailment from which he suffered have rendered his intellect and attacked his emotions, or indulged in certain unusual acts, or had fits of insanity on short intervals of that he was subjected to epileptic fits, and there was abnormal behavior, or the behavior is queer or not sufficient to attract the application. So here it was clearly mentioned that how to prove legal insanity and not medical insanity. This is a brief with respect to section 22, that is legal insanity or unsoundness of mind. Thank you.